All right, good morning. Thank you so much for joining me. Today, we are going to be discussing Social Security disability claims for individuals between 50 and 54 years old. Before we go any further, I do want to make a statement that this webinar is not considered legal advice. It is a broad overview. I can't give legal advice in the webinar because I don't know the specifics of your situation, and every situation is going to have certain nuances. So if you do have specific questions and would like to seek legal advice, feel free. My contact information will be at the end of the webinar. You can reach out to me directly and we can kind of set up a time to have that conversation so I can better understand your specific situation, and if I'm in a position to then give legal advice based on your specifics. So again, this webinar is meant to be an overview, give you a little bit better of an understanding of disability claims, again, specifically for claims between the ages of 50 and 54, as there are some special rules that apply. So stick along. So first, we are going to cover Social Security disability basics, kind of lay the groundwork for understanding what the Social Security disability process is. Then we will move into a discussion about the listings, and then a discussion about the grid rules. And then finally, I always end all of my webinars with how an attorney can help you. Not everybody knows how attorneys can help, so that's why I do discuss that. A little bit about me. Again, my name is Caitlin Wildoner. I am the founding attorney of Beacon Disability, PLLC. It is a law firm based in St. Johns County, Florida. However, with respect to Social Security disability, we exclusively practice federal administrative disability law. So that means that if you are anywhere in the country, we can answer questions that you might have about the disability process at the agency level. If you have a federal appeal, that is likely not something that we can help with, but initial application, reconsideration, hearing stage, even sometimes the appeals council, those are things that we can help you with, as Social Security is a federal practice area. Okay, so moving into a little bit about Social Security disability basics. So there are the two programs. There's SSDI, which is Social Security Disability Insurance, and then there's SSI, which is Supplemental Security Income. Both programs, as you'll see, those first three listings, they both require that you be disabled for at least 12 months. And during those 12 months, you're disabled and unable to work. And that disability stems from a physical and or mental impairment. So there's no such thing as temporary Social Security disability. You have to be disabled for at least 12 months. It doesn't mean that you have to wait 12 months before applying. And in fact, I often encourage clients to apply sooner rather than later. But it means that you must be expected to be disabled and unable to work for at least 12 months, again, due to physical and or mental impairments. Okay, the difference where the two programs separate is with SSDI, you have to have sufficient work credits. Generally speaking, and there are nuances to this, there are exceptions to the rule. Generally speaking, for SSDI benefits, you have to have worked 5 of the last 10 years. You have to have 20 of 40 credits, which generally equates to 5 of the last 10 years. Again, that's a very general, broad kind of description. But that's why if you call a lawyer's office, they'll often ask you, did you work 5 of the last 10 years? And that's where they're coming from. For SSI benefits, on the other hand, it doesn't have that work requirement, but it does have income and asset restrictions. It's more of a welfare-based program. So it's going to make sure that you don't have money sitting in the bank that you could, in theory, use before relying on this program. So the asset restrictions don't include one house and one car, but they do include bank accounts, investment accounts, retirement accounts, things like that. And if you are single, that restriction is $2,000. Anything over $2,000 is going to make you ineligible. And if you're married, that amount bumps up to $3,000. Again, there are one house and one car, kind of the broad brushstrokes that I use to explain some of the exceptions. There are other exceptions, and then income, that does vary as well. Social Security uses a 5-step evaluation process to determine whether you are disabled according to their rules. Almost all my webinars, we cover this because it's so important to get you to understand why Social Security might be saying you're not disabled when you think it's pretty clear that you are. So here's where Social Security goes. First, they look at, are you engaging in substantial gainful activity? Right now for 2022, that's described as $1,350 gross earnings per month. $1,350 in gross earnings. So that's before taxes are taken out, before health insurance is taken out, all of that. Are you earning $1,350 a month gross or more? If so, you're engaging in substantial gainful activity, and Social Security will not continue to evaluate the case. They will automatically say you're not disabled by definition. Even if you're not earning that much gross per month, if you're working 20 hours a week or more, that also pushes you out of definition of disability. Okay. If you're kind of on the cusp of those, call a lawyer, talk to them about what you might want to consider, because there's a little bit of gray area there. If you are not engaging in substantial gainful activity, Social Security will move to step 2, which is, do you have any severe medically determinable impairments? If not, Social Security will say you can't be found disabled because you don't have any severe impairments. If you do have severe impairments, Social Security moves to step 3, which is, do you meet or equal a listing with those impairments? If so, the evaluation will stop there. But instead of, similar to at the first two, how Social Security stops the evaluation and says you're not disabled, at step 3, if the evaluation stops because you meet a listing, you are disabled. Okay. If you are not found disabled at step 3, if you don't meet or equal a listing, Social Security will move to step 4, and they will determine, based on your residual functional capacity, can you go back to your past work? So Social Security reviews the file, they come up with a residual functional capacity, which is basically an evaluation of what they think you're capable of performing based on the medical records. If based on their RFC that they've created, you can go back to your past work, then Social Security will stop the evaluation and they will find you not disabled and say you can go back to your past work. If based on that RFC, you cannot go back to your past work, Social Security will move to step 5 and say, okay, you might not be able to go back to your past work, but is there any other work that you can do? And so it's at this step 5 that the age really comes into play. Okay. Can you engage in other work? And this week, we're talking about individuals aged 50 to 54. 2 weeks from now, on April 27th, we'll be talking about claims for individuals 55 and up, because new rules apply then too. So it's very exciting. With Social Security, a birthday is very exciting if it pushes you into a next age category. All right, so that's kind of the background. Now looking at the listings, which is also known as the Blue Book. They cover 14 broad categories, and they contain medical criteria that apply to the evaluation of impairments in adults. And I will see if I can click here, see if it will. I think it's sharing. So you can kind of see here how it works. It's separated by these 14, which we'll talk about on the next slide as well. And if you click on just one, you can see that it doesn't just cover 14 impairments, but that here we go. We've got 1, 2, 3, 4, 5, 6, 7, 8, 9 listings that are considered under musculoskeletal disorders. So Social Security considers a couple disorders for the back. They've got here, if you've had reconstructive surgery on a major weight-bearing joint, they will consider that here. If you haven't had reconstructive surgery, but you still have abnormalities in one of your major joints, they'll consider it here. Any kind of fracture, amputation, soft tissue injury. And you can kind of get an idea on some of the listing titles, what they're looking for. So here, if we look at 1.21, you'll see that it's got to be a soft tissue injury or abnormality that's under continuing surgical management. Okay, so it's kind of got a little bit, it's not just any soft tissue injury, but it's got to be under continuing surgical management. And if you go here, you'll see, okay, here's what they really specifically are looking for. It's got to be met by A, B, and C. So there's got to be evidence that confirms that continuing surgical management. There's got to be at least 12 months that surgical management is either going to be going on for or already has been ongoing. And you have to be able to prove that the maximum benefit from the therapy hasn't yet been achieved. And so you can see when you look at these listings, there's all kinds of links inside, and you can click around and see and kind of get a really good understanding of what Social Security is specifically looking for. It can be very tricky, very hard to understand because these listings are so strict. So the listings can be very, very helpful. This is the link for the here, or you can just Google Social Security Bluebook, Social Security listings, and it's usually one of the first few that pop up. You want to make sure that you are under the adult listings when you're looking at that. There's an adult listings section and a child listings section. Make sure, especially since we're talking about 50 to 54-year-olds here, look at that adult listing section because that's going to give you an understanding of what specific medical evidence Social Security is going to be looking for. As we'll talk about in a minute, if you don't meet a listing, it's not a dead end. It's not the end of the world. The listings, the bar is set very, very high. So if you don't meet a listing, it's okay. You might still be able to be found disabled based on your RFC that we were talking about before, and that we'll talk about again shortly. Okay, so as we just kind of looked at very briefly, there are 14 categories in the listings, from musculoskeletal disorders, special senses and speech, respiratory disorders, the cardiovascular system, the digestive system, hematological disorders, skin disorders. Endocrine disorders is actually a very interesting listing subset because it is just one. So there's, if you've got diabetes or something like that, look at listing 9 basically, and it will explain to you kind of what Social Security's thought process is around that. Generally speaking, if you've got diabetes that's preventing you from working, there's other stuff at play too, neuropathy, things like that. And neuropathy often falls under category 11, which is neurological disorders. There's actually a whole bunch of listings under there. Mental disorders has a handful of listings. Cancer's got a lot of different listings. A lot of specific cancers are called out to show you what exactly Social Security is looking for if you have been diagnosed with a specific cancer. So that can be very helpful. And then immune system disorders as well. Okay, so moving to the residual functional capacity. Here are Social Security kind of, they really only look at the first 3, which is why there's a description of them underneath. But you might hear, if you have a hearing, you might hear the vocational witness classify your past work as heavy or very heavy. Oftentimes this happens in some jobs in the medical field, some jobs in construction, where you are constantly, or at least, occasionally, frequently lifting heavy weight. So as you can see, the sedentary exertional level is going to limit you to lifting no more than 10 pounds and only occasional walking or standing. Okay, the light exertional level bumps that up a bit. And at the light level, you can lift or carry up to 20 pounds occasionally and 10 pounds frequently. And instead of only occasional walking and standing, light jobs will often require more frequent walking or standing. Again, the medium exertional level bumps it up even more, that you can lift and carry up to 50 pounds occasionally, 25 pounds frequently, and it's got a frequent standing and walking component to it generally. Okay, and as I mentioned, Social Security, they don't often say somebody can go back to work at the heavy exertional level or the very heavy exertional level, but those are also there. You might hear a vocational witness talk about them in the hearing, so I didn't want to totally leave them off. But those first 3, sedentary, light, and medium, are generally where Social Security likes to hang out and likes to assign people. Another important component to understand is work can be either skilled or unskilled. And within skilled, there's actually 2 subsets. It's skilled or semi-skilled. So kind of taking them in order, the first is unskilled work. Unskilled work is work that needs either a little bit or no judgment, and it tends to be simple duties that can be learned on the job in a short period of time. Okay, sometimes sorting jobs will fall into this unskilled category. Up from that is semi-skilled work, which is work that does require some skill, but doesn't require more complex work duties. And then skilled work, of course, is work that requires certain qualifications and that a person uses judgment to determine, sometimes it's machine and manual operations to be performed. Sometimes a lot of, again, going at the medical field, that tends to be skilled. There's actually a lot of jobs in construction that fall into all three of these categories. There's a lot of jobs really in general that fall into all three categories. Where these tend to get knocked out is not necessarily on the physical component, but more on the mental. Do you have pain or fatigue that prevents you from thinking in the way that you used to be able to think? Do you have anxiety or depression that impacts your ability to function? Things like that. That's where this comes in. The skilled, semi-skilled, unskilled is not so much the physical component of the RFC, but it is included in the overall evaluation of an individual, especially as we'll see, I think it's on the next slide where we start to talk about the grid rules, which really begin to be helpful and apply at age 50. And today we are going to look at specifically the grid rules for those that are closely approaching advanced age, which is, I guess, a polite way of saying individuals who are between 50 and 54. If you're under age 59, if you're 18 to 49, you are considered a younger individual. If you are 50 to 54, you're closely approaching advanced age. And if you are 55 to 60, you are advanced age. So today, since we're talking about 50 to 54, as you can see here on the slide, we're looking at closely approaching advanced age. So these grid rules are specific to sedentary work. There's a couple different columns. That first column there that's got all the 201.09, 10, 11, 12, those are the grid rule numbers. Okay, so if you have an attorney who's representing you at the hearing, you might hear them discuss with the judge. If they think you meet a certain grid rule, you might hear them say, Mr. or Mrs. Smith meets grid rule 20111 as they are closely approaching advanced age. They have a limited education and or actually you wouldn't want to say they make 20111, you'd want to say 20110. Again, closely approaching advanced age, limited education, and you might have skilled or semi-skilled work, but those are not transferable to other jobs. So as such, he or she should be found disabled. Okay, so that's kind of how you read it going across. So as you'll see that second column there on what we're looking at, it's all for those individuals between 50 and 54. That third column that starts with limited or less, that's education. Social Security breaks education into a couple different categories, being limited or less, which is less than a high school diploma. And then you'll see that the next category is high school graduate or more. So if you have your GED or your high school diploma or a bachelor's or a master's or a MD, DO, JD, whatever it is, that's where they're kind of coming at from this particular column. That gets broken down a little bit further, as you can see, into, okay, you've got that high school diploma at least or more. Can you go directly into skilled work? If so, you'll see that that will often find you not disabled if you can make a direct entry into skilled work. If you cannot provide that direct entry into skilled work, then that's where you will often be found disabled unless you've got transferable skills to other skilled or semi-skilled jobs. Okay, so this is the grid rules for sedentary. You'll see that fourth column talks about skilled, unskilled, transferable skills. That's what that's all for. And then the very last column is whether or not you would be found disabled under that rule. So you read it all the way across. As you'll see, there are several avenues forward. If you're limited to sedentary work between 50 and 54, there are several avenues for being found disabled, largely centered around a limited education. However, if you are a high school graduate or more and you cannot go into direct, you don't have that ability to go directly into skilled work. If you either have unskilled past work, no past work, or you have skilled or semi-skilled but no transferable skills, that's where you'll find that finding of disabled. So as you can see, sedentary work between 50 and 54, if you have no transferable skills, can be very, very helpful. Here we're looking at the grid rules for light RFC. So these are, all the columns are the same. And as you'll see, they start with 202 this time instead of 201. So that's how you know you're looking at light. Closely approaching advanced stage, that's the category we're looking at between 50 and 54. And as you'll see, the education levels change a little bit here. Here, everything is not disabled. If you can do light work between 50 and 54, as long as you are at least literate and able to communicate in English, the grid rules don't really help you. So between 50 and 54, the grid rules are really helpful if you're at sedentary work and those other caveats that we just discussed. Light work can be helpful between 50 and 54 if you are either illiterate or unable to communicate in English, and if you have either unskilled or no past work. That will result in the finding of disabled. Everything else, there are light jobs that you can do between 50 and 54. If Social Security has assigned you to medium work or greater, sometimes this happens with, if it's strictly, a mental only claim and physically you're in great shape, it will likely result in the finding of not disabled. However, there are other rules that might apply. And again, if it's focused on the mental health, that this is all focused on physical. So just because Social Security says you can do medium work, if you've got significant mental limitations with the RFC, they might preclude all work. Okay. However, a worn out worker rule, say that 3 times fast, might apply also. The worn out worker rule is if you have a marginal education, if you have work experience of 35 years or more doing only arduous, unskilled physical labor, if you are not working and you are no longer able to do the work you've done for the 35 years because of a severe impairment, you might be found disabled, even if you are able to do medium work. This doesn't happen all the time. It is a special kind of rule that kind of really can only kick in once you hit these certain ages, because it does have that work experience requirement of 35 years or more. So you have to meet all 4 of those prongs in order to meet the worn out worker rule. Like I said, it's not a very common thing, but it does happen. So I did want to at least make sure we mentioned it. All right. So finally, we're in the how can an attorney help you stage. So throughout the entire process, an attorney can help you with several things. Number 1 being they can provide guidance on what correspondence from Social Security actually means. Social Security sends out a lot of form letters, a lot of letters that aren't super easy to understand. And having an attorney on your side can really help explain what this form means, what kind of responses you'll want to provide, and what to expect after you send that back in. An attorney can also help file necessary appeals if you hire them within the requisite time frame. And an attorney will also review your medical records and case file. In addition, so that is at all stages, including appeals counsel, at initial through reconsideration, an attorney can also help review documents for accuracy and completeness, discuss what Social Security is looking for in those requested forms, work with you and Social Security to provide relevant updates back and forth. If you're at the hearing level, an attorney should prepare you for that hearing before an administrative law judge. And at the hearing, the attorney can ask questions of you and or your witnesses if they are permitted. I appreciate you joining today. Here, as promised, is the contact information. Feel free to give us a call directly. That's our phone number. You can shoot us an email. If you want to set up a time, we've got, I think it should be posted on the replay and we can put it in the chat here as well. Usually there's a link if you want to schedule a call directly with me. You can do that as well at a time that's convenient for both of us, or send an email, give us a call. Again, we assist clients throughout the United States at agency level parts of the Social Security Administration, and our main office is in St. Johns County, Florida. If you have questions, feel free to reach out. I truly do enjoy helping others. I appreciate your time today. Thanks so much, and I'll talk to you soon.